Thanks so much, Doug. He just asked if there was anything he should say when he introduced me, and I gave him the data about my animals. And clearly he's a data guy because he remembered that without writing it down. It's good to be here. Good to be here. So thank you for the introduction that mentioned my dear animals, and thanks also to the American Action Forum for hosting what is a really important event. We are in the run-up to the 2024 presidential election, and it is appropriate to take stock of what's happening with our government and with our economy. And it's time to reflect on the performance of the FTC under President Biden. So what impact have Chair Khan's policies had on the FTC and on consumers? I don't think my views are going to surprise you. I've been pretty vocal about what I think. But let me just restate, I believe the current FTC has imposed significant harm on both the FTC as an institution and on consumers that the agency is charged with protecting. My conclusions are based on a long affiliation with the FTC. Doug ran through the 3 different stints that I had at the agency, including under Chairman Miras, from whom I learned essentially everything I know about antitrust and consumer protection, and how to effectively run an agency. And during that affiliation with the agency, I have seen the FTC accomplish wonderful things. I was there under Tim when we enacted the Do Not Call registry. And to this day, that protects Americans from telemarketers. Day in and day out, the FTC shuts down fraudsters and thieves who steal hard-earned money from consumers. And over the decades, the FTC's international division has worked with sister agencies around the globe to install the consumer welfare standard as the appropriate one for antitrust enforcement. They've worked hard. They've used bilateral and multilateral fora, and they have done, they've been a shining example of achieving harmonization and convergence around sound policies. And this standard that they have gotten other jurisdictions to adopt around the country appropriately makes consumers the touchstone, not national champions and other interests, which is important for trade. These and other actions that the FTC has undertaken have promoted competition, prevented fraud, and protected consumers. On balance, the FTC that I grew up with has been a force for good. But between my first stint at the FTC and my last, the agency has changed dramatically, and definitely not for the better. Before the neo-Brandeisians arrived, the agency spearheaded the worldwide effort to develop and implement best practices for competition policy grounded in sound economics. It placed consumers first. It enjoyed bipartisan support from Congress, and it avoided politicization. It respected the due process rights of the companies that appeared before it, and it had the support and admiration of a proud staff. Under the neo-Brandeisians, we've seen a very different story. The FTC has thrown out the last 40-plus years of legal and economic development. Instead, they have embraced a new enforcement regime that is hostile to free market forces and profitable business. They've politicized antitrust enforcement. Indeed, Chair Khan has said that all decisions are political. They've rejected the consumer welfare standard, and instead they've adopted a focus on labor and other special interests. As an aside, neo-Brandeisians believe that the analytical framework, the consumer welfare standard, was designed by elites to favor business at the expense of workers. The depth of their animosity cannot be overstated. One neo-Brandeisian told a large gathering of antitrust enforcers and practitioners that their support of the consumer welfare standard was responsible for the destruction of American democracy. He compared antitrust practitioners to Vladimir Putin and Xi Jinping. And another neo-Brandeisian who has co-authored articles with Chair Khan states that, quote, an antitrust enforcer anchored in consumer welfare is an antitrust enforcer anchored in anti-labor. Why? In their eyes, low prices for consumers equate to theft from workers. They've suggested, in fact, that low prices could constitute an unfair method of competition under Section 5 of the FTC Act. So back to our list. What else has happened to the FTC since the Neo-Brandeisians arrived? The FTC has hemorrhaged talented staff because of poor management and leadership's lack of integrity. The FTC has ignored the rule of law, due process rights, and agency norms, and they have degraded the international consensus on sound enforcement and best practices. Nowhere is the hostility to business more apparent than the FTC's merger enforcement program, where the agency's goal is quite clear: to prevent as many mergers as possible. The current administration has a relatively simple worldview. Big is bad. They will protest that in fact is their worldview. While they occasionally purport to focus on levels of concentration, though, their own writings repeatedly describe an aversion to large corporations. There are two related subthemes that go with this worldview. They believe that labor is disadvantaged as corporate power grows. And recall that labor is the key constituency, not consumers. And they believe that mergers generally do not produce cost savings, but that even if they do, those cost savings are in fact harmful to rivals and to labor, and are therefore negative. Much ink has been spilled in recent weeks to assess the agency's merger enforcement record, and the FTC has had some recent victories. The Fifth Circuit recently affirmed the FTC's decision to block Illumina's acquisition of Grail. Now, commentators have pointed to this decision as validation of Chair Khan's antitrust agenda, but I was there and I disagree. Close observers of the commission will recall that the Illumina Grail complaint was voted out by a unanimous and bipartisan commission. Both Commissioner Noah Phillips, sitting in the front row, and I supported the enforcement action. It wasn't a borderline case espousing a novel theory of harm. It presented relatively straightforward vertical foreclosure issues that can arise when you combine two firms in a concentrated supply chain. Reasonable minds may see the evidence differently, but this was by no means a revolutionary case. The story of Illumina Grail isn't one of aggressive agency action or novel theories of harm, but rather of basic economics and the importance of case-specific facts. On the other hand, when the agencies have pursued more novel cases that seek to reimagine the antitrust laws or resurrect enforcement policies from the Stone Age of antitrust, the FTC hasn't fared nearly as well. Take, for example, two cases that I voted against. The first was Meta's acquisition of virtual reality fitness app maker Within. The judge denied the FTC's request to enjoin the transaction. He found that the agency failed to substantiate its assertion that Meta was likely to compete in a market for VR fitness apps absent the transaction. Basically, the commission argued that Meta could have and should have expanded by creating its own product rather than buying Within. Now, interestingly, consider what happens if you flip this argument. This argument could be used by merging parties against the FTC in other deals. If we say Meta can and should have entered here, given its vast resources, surely it could enter many other lines of business with ease. Merging parties who do business in a sector that's adjacent to Meta, or Amazon, or Google, or Apple, and so on, could argue that given their resources, these companies should be viewed as potential entrants. In fact, a whole host of potentially problematic deals would become innocuous if we applied the government's own conception of potential entry as a defense. And the merger guidelines, the new merger guidelines, attempt to address this problem in section 2.4.c. It's called Distinguishing Potential Entry from Entry as Rebuttal, by arguing that somehow this situation is different. There's another problem with this case, though. Substituting the government's judgment for business judgment on the make versus buy decision has dangerous implications. But this same strong preference for organic growth that showed up in Meta also shows up in the new merger guidelines. An expansive approach to so-called less restrictive alternatives to a proposed merger puts technocrats, not business people, in the driver's seat. The second case that I voted against was Microsoft's proposed acquisition of Blizzard Activision, a vertical transaction in the gaming space. From the early days of the proposed merger, Microsoft proactively committed to remedy the harm alleged by the FTC. It agreed to make Call of Duty widely available to competing platforms. The FTC nevertheless pursued the case. The district court ultimately denied the FTC challenge, saying there could be no harm because Microsoft fixed the issue contractually. This case seemed more motivated by the desire to protect Sony, a dominant competitor, than by a desire to protect consumers. But that is a trend that we see, a desire to protect competitors, not competition and not consumers. If current FTC leadership confined their war on mergers to the courts, that would be less objectionable. Instead, they have used every lever of power at their disposal to increase the cost and heighten the risk of doing deals. This includes easy-to-implement procedural gimmicks that can have serious costs on transactions. In August 2021, I warned that the HSR Act was suffering death by 1,000 cuts. And these changes are all about throwing sand in the gears of M&A, which is one of Commissioner Phillips' favorite phrases. So what did they do? First of all, as soon as COVID hit our shores, they proposed a moratorium on mergers. And the Hill actually seriously considered that. They eliminated early termination, which cuts short the statutory 30-day waiting period for deals that present absolutely no prospect of antitrust harm. They're holding parties hostage by forcing them to agree to get, quote, prior approval for future non-reportable deals. And this policy came into effect when Noah was at the commission with me, and it's what prompted the phrase zombie votes. They send so-called warning letters advising merger parties that although their transaction has observed the statutory waiting period, the FTC has not closed its investigation and may still pursue a challenge. This creates unnecessary certainty, of course, and it keeps merging parties looking in the rearview mirror instead of investing in the future. And they've extended investigation timelines and demanded the production of large volumes of irrelevant information from the parties. So these and other actions have increased the cost and heightened the uncertainty of proceeding with mergers. And based on anecdotal evidence, just talking to other practitioners in the field, I do believe these actions are chilling M&A activity, at least at the margins. And when you're struggling to avoid a recession, you don't need an agency to put a wet blanket on the economy. The most recent initiative on the procedural front involves revising the HSR notification process to make it far more burdensome and costly. Specifically, parties whose deals meet certain thresholds must notify the federal antitrust agencies of their intent to merge. Under Chairman Simons, the FTC proposed to add certain lines of inquiry to the HSR form. That relatively modest proposal has been sidelined. Instead, the Neo-Brandesians recently proposed overhauling the merger notification process. And their proposals go far beyond updating the HSR form. They're essentially proposing to transform the HSR process into a notification process that looks like a miniature second request. When evaluating the proposed changes, some context is useful. And I think Diana's going to get into some of these numbers on the panel. During the last several administrations, regardless of which party is running the federal antitrust agencies, on average, at least according to one calculation, 3% of all proposed transactions are subjected to a closer look. In other words, roughly 97% of deals are eventually viewed as either neutral or competitively beneficial. Against that backdrop, consider the increase in time and money that's required by the new proposal. According to the FTC's estimates, it takes an average of 37 hours to complete the HSR filing as it currently stands. The FTC itself estimates that with the new proposals in place, the HSR form would require 144 hours to complete. And somehow the FTC concludes, despite these data, that the incremental burden would be minimal. I think the FTC's estimates are conservative. The U.S. Chamber of Commerce conducted a study of U.S. antitrust practitioners to obtain informed estimates of both the current and anticipated preparation times. Survey respondents estimated that outside counsel currently spends an average of 54 hours per transaction preparing and submitting information for the initial filing, and they estimate that the new requirements will add 140 hours. In other words, the time to prepare an HSR form will nearly quadruple to about 194 hours from 54 hours. Now, is it conceivable that some small percentage of deals actually does present competitive issues, but is being overlooked? Perhaps, but the FTC didn't provide evidence to this effect. And neither does the FTC describe how all of these mountains of new filing information will be reviewed. The FTC will either need a huge increase in FTEs or a significant restructuring of the statutory waiting periods to deal with the increased data volume. And I think the current FTC leadership would welcome either of those or both of those propositions. And then let's keep in mind that this hefty new burden would be imposed on all transactions, including the significant percentage of deals, estimates between 50, 70, 80% of deals that received early termination because they present absolutely no competitive harm. This new proposal only makes sense when you remember that the Neo-Brandesians' desire is to halt merger activity completely. But it doesn't stop there. The Neo-Brandesians have also undertaken substantive initiatives to support a more aggressive merger enforcement agenda. Early in her tenure, Chair Khan withdrew the vertical merger guidelines issued jointly by the DOJ and the FTC during the prior year with very little notice to Noah and myself. The guidelines provided the first update in decades on how the agencies review vertical mergers. They embodied sound law and economics, and they provided important business guidance. And remember, this was shortly after COVID had become less of a threat, but supply chain crises were still rampant. And so many businesses were looking to shore up supply chains by engaging in vertical mergers, and Lina withdrew the vertical mergers. Notably, DOJ did not, which means you have two federal antitrust agencies, one abiding by vertical merger guidelines and one not, which is obviously not good government. More recently, the FTC and DOJ issued draft and then final merger guidelines in 2023. And as many of you know, the first merger guidelines were issued in 1968 by the DOJ, and they have been updated by both federal agencies periodically since then. These changes have captured advances in economic learning and enforcement policy. And the guidelines are very helpful to business because they outline the analytical framework for determining whether a merger is unlawful. Prior to their most recent iteration, the guidelines were last revised in 2010. Now, the 2010 horizontal merger guidelines were, by all accounts, a huge success. There was some debate around the margins, but they reflected a consensus and bipartisan view of the proper analytical framework for merger enforcement. Although the guidelines aren't binding on the judiciary, courts regularly cited the 2010 guidelines as persuasive guidance to support their merger analysis, likely because the guidelines did enjoy a broad and bipartisan consensus. Now, the 2010 guidelines reflected a trend toward focusing on analyzing actual competitive effects instead of simplistic market share calculations. Given the development of new case law and new economic tools, I don't think it was wrong for the Biden administration to conclude that the 2010 guidelines could benefit from some updating. And I think Noah and I issued a statement to that effect. Great, let's consider how we can update these in keeping with sound economics and legal developments. But the goal of this update was not benign. It was almost certainly to give authority and credence to the more hostile and often more novel approach to merger enforcement championed by the Biden administration. They launched the Merger Guidelines Project with a request for information, and a quick review of that document revealed just how one-sided the process was going to be. While the 2023 merger guidelines include several structural and substantive changes, I'd like to highlight what I believe to be just some key changes. The first is the treatment of economics. The draft guidelines revealed current leadership's true perspective on economic analysis by placing that section in an appendix. Everyone who practices antitrust law knows economics is key to reaching the right outcome. The discussion of economics has now been moved to the body of the merger guidelines, but I think this change is window dressing because we know they disfavor the use of economics. Indeed, a key ally and former colleague of Chair Khan, named Matt Stoller, asserts that, quote, the point of economics as a discipline is to create a language and methodology for governing that hides political assumptions from the public, close quote. One line in the final guidelines tips their hand, quote, the agencies do not attempt to predict the future or calculate precise effects of a merger with certainty, close quote. You can drive a truck through that loophole. A second key point about the new merger guidelines, the emphasis on labor as an input. Now, to be clear, analyzing the effect of a merger on competition for labor as an input is not new. If you only listen to the neo-Brandesians, you're going to hear a different story. This analysis was frequently undertaken under Chairman Simons, particularly in hospital cases. And if you're interested, take a look at the Grifols case that we voted out. Most of the text about competition for labor as an input in the new merger guidelines appears non-controversial on its face. But again, two sentences tip their hand. First, the merger guidelines note that, quote, the level of concentration at which competition concerns arise may be lower in labor markets than in product markets, given the unique features of certain labor markets, close quote. And second, the merger guidelines note that, quote, in light of their characteristics, labor markets can be relatively narrow, close quote. These comments reveal, I think, labor is going to become a significant tool to block mergers. The third key point I'd like to make is lower concentration thresholds. The new guidelines lower the threshold for what constitutes a concentrated market and a presumptively unlawful merger. Now, my former attorney advisor, Keith Clovers, and I did some analysis on the legal definitions of product markets over time. So we took a look at what lines of business constituted relevant product markets in much older cases and in newer cases, trying to compare apples to apples across time. And what we found is that, in fact, product market definitions have significantly narrowed over time. And narrower product market definitions typically means fewer competitors in the market. So when you combine the trend toward narrower product markets with the lowering of concentration screens, you get a double whammy here. The fourth point that I'd make about the new merger guidelines is that they contain much tougher screens for efficiencies. For example, the new guidelines remove prosecutorial discretion to consider out-of-market efficiencies. The 2010 guidelines permitted the use of prosecutorial discretion for this purpose. Now, the position isn't surprising. We know the current FTC leadership believes efficiencies to be, number one, rarely achieved, and number two, if they are achieved, harmful because they disadvantage competitors and labor. In fact, the new merger guidelines cite the Procter & Gamble case from 1967 that views efficiencies as an argument against the merging parties. In a similar vein, check out the way the request for information that launched this process talked about efficiencies. And look at the way the House Judiciary Committee report that Lina penned proposed to treat product innovations, basically unlawful if they inconvenience rivals. And again, going back to the research that I did with Keith Clovers about the scope of product market definitions over time, if you exclude out-of-market efficiencies, when combined with narrowing markets, again, you're going to have an outsized impact. And the last point that I'd like to make about the new merger guidelines is that, very oddly, basically they lump vertical mergers in with horizontal mergers. Obviously, there are significant differences between the two. Horizontal mergers, by definition, eliminate at least some competition, and the relevant question is, how much? In contrast, vertical mergers involve companies at different levels of the supply chain and typically generate at least some efficiencies. And the differences between these two categories of mergers, appropriately until now, have resulted in analytical frameworks with different focuses. Now, only time will tell how the courts will react to the 2023 merger guidelines. I doubt they will be embraced as routinely and as enthusiastically as the 2010 guidelines were. Stepping back, it's worth mentioning that all of these initiatives, both substantive and procedural, have been pursued by an FTC chair who believes that the ends justify the means. Current leadership has no regard for the rule of law and due process. For example, due process requires that all actors be treated equally in the eyes of the law. But the neo-Brandesians disfavor certain sectors like private equity and big tech, and they single them out for separate and special treatment. This differentiated treatment shows up both in the merger guidelines and the proposed reforms to the HSR Act. We can debate the merits of these various initiatives that I've outlined, but there's an even bigger question. Are there reforms that should be undertaken in light of the developments of the last 2.5 years? And can someone tell me how much time I have, and I'll know how quickly to go through the changes? 10 minutes? Okay, great. So I'd like to propose 5 core reforms to safeguard the FTC. First, I think we need to enshrine the consumer welfare standard in a law. The merger guidelines again underscore the FTC's desire to use the antitrust laws to benefit groups other than consumers. Now, we shouldn't be surprised. Elizabeth Warren, a close ally of the neo-Brandesian movement, introduced a merger bill recently that would require the agencies to evaluate the impact of each merger on the following: the parties' business ecosystems, including workers, consumers, customer choice, small and minority-owned businesses, including farms and ranches, I guess I would benefit, local, rural, and low-income communities, communities of color, privacy, quality, entrepreneurship, and innovation. Now, granted, some of the itemized factors in that list are subsumed within the consumer welfare standards: choice, quality, innovation, but the remainder of the list adds a host of considerations other than consumers writ large. So I think we need to enshrine the consumer welfare standard in legislation or watch the FTC remain mired in public interest feuding. The FTC had remained above the fray, respected by all, until it got politicized. Why make it like every other ill-respected body in Washington, D.C.? With respect to the consumer welfare standard, the current administration is incredibly disingenuous on at least 2 fronts. I think folks involved in this debate know this. First, the neo-Brandesians argue the consumer welfare standard only gauges price. In fact, it takes into account a variety of factors like quality, convenience, etc. To a topic that Diana and I have discussed before, consider the merger of Northwest Airlines with Delta Airlines. The analysis that we presented to the Department of Justice, and Tim, I worked for Tim on this one, we used the Quality Service Index to convince DOJ that this was going to be a favorable deal for consumers. So we developed a model that measured consumer preference for a host of factors, including nonstop versus one-stop, regional jet versus a larger aircraft, and so on. And then the model was able to measure consumer benefits across many facets of competition, and the DOJ economists admitted that this tool was valid. So clearly, the consumer welfare standard measures many factors, not just price. And second, the neo-Brandesians argue the consumer welfare standard is not administrable, but that somehow their approach is. I guess it depends on how you define administrable. If it's the interest group that screams the loudest wins, maybe their approach is administrable. But that approach doesn't provide predictability and certainty to businesses, and that predictability and certainty is necessary for investment and for innovation. and it certainly doesn't imbue the agency with credibility. Winston Churchill said that democracy is the worst form of government except for all others that have been tried. The same is true of the consumer welfare standard. I'm open to other standards, and we had these discussions when Joe Simons was chair. We talked about various possible alternatives. But any standard that's chosen must prove predictable, administrable, and credible. And so far, it's the consumer welfare standard that has measured up to that test. But a public interest standard, which is basically what the FTC is now using, fails this test, and it tarnishes the agency in the process. Second, we need to solidify economics as the bedrock of competition enforcement. Let's assume we retain the consumer welfare standard, and then the next job is how to measure against that standard. We know that the FTC has deprioritized economic analysis under Chair Khan, but I am a huge fan of the FTC's Bureau of Economics. I think it has an incredibly important job to do on both the competition and the consumer protection sides of the house. No, the economists and the lawyers don't always see eye to eye, but listening to the economists is important. So I think we need to bolster the economic analysis. Third point, we need to rebuild the FTC's merger review regime and restore good governance. So as I have described, the FTC has implemented many measures for the express purpose of chilling M&A activity. And these measures affect all mergers, not just the anti-competitive ones, and they need to be rolled back. So specifically, we need to reinstate issuing early termination of the HSR waiting period in appropriate circumstances. We need to downsize Chair Khan's proposed changes to the HSR rule. I would note some of them are statutorily mandated. We need to address the Simons-era proposed HSR rule changes, which had merit. We need to rescind the new prior approval policy that's used to target PE deals in particular. We need to renounce the use of pre-consummation warning letters, which are intended only to have an interorum effect. To all of the mergers that have received those pre-consummation warning letters, we need to send letters saying the investigation has been closed. And we need to limit investigations to legally relevant topics. We also need to return merger enforcement policy to legally and economically sound principles. We need to withdraw the new merger guidelines, replace them with the 2010 horizontal merger guidelines and the 2020 vertical merger guidelines and commentary. Those may need to be updated. I'm happy to have that discussion, and there are topics that could bear updating in the 2010 merger guidelines and maybe even in the 2020 vertical merger guidelines, perhaps to reflect what we learned in the Illumina Grail decision. We need to confine merger investigations to the consumer welfare standard, and we need to disavow consideration of labor in any context other than competition for labor as an input. We need to build into the merger review process a serious analysis of the potential benefits of proposed mergers, not just lip service, but actual consideration. And I think we should find an appropriate vehicle for modernizing Supreme Court merger precedent. Let's find a test case. Number 4, this may be where I lose Tim. Let's reform the Part 3 process so that it's effective and respected. The FTC has the authority to bring cases in its own administrative court. Detractors have long criticized the capability for at least 2 reasons. First, the critics say that the FTC has a kangaroo court because the commission first serves as a prosecutor when it brings the case, and then it serves as a judge if the case is appealed to the commission after litigation. And the second criticism arises because both the FTC and DOJ have the authority to review proposed mergers, but the procedures differ depending on which agency reviews the deal. People argue about whether the substantive standards differ, but even the appearance of divergence is problematic from a good government perspective. So to address these 2 criticisms, particularly in light of the new merger guidelines, I would suggest that Congress require the FTC to bring merger challenges in federal court and only in federal court. And then we have to consider what's left of the Part 3 process. And if we believe that Section 5 of the FTC Act and unfair methods of competition is now coterminous with the antitrust laws, Do we need Part 3 at the FTC anymore? Perhaps for consumer protection cases. Number 5, we need to recalibrate our relationships with domestic and foreign agencies. The FTC and DOJ have long played an important role within the domestic arena, doing what we antitrust lawyers call competition advocacy. Yes, other federal and state agencies have mandates like public health and safety and so on. And we understand competition may not be their primary concern, but competition advocacy reminds other agencies that regulations may have an impact on the level of competition that consumers enjoy. So we encourage the agencies to include that impact in their calculus. But this FTC has gone way overboard, including cozying up to the National Labor Relations Board. They have an MOU with the NLRB. So domestically, the FTC must avoid exercising its authority by or for the benefit of other regulators and for beneficiaries other than consumers. So the FTC should rescind the Memorandum of Understanding with the U.S. Department of Labor and the U.S. National Labor Relations Board. On the international front, we also see the U.S. overstepping its bounds in a variety of ways. Since I was a wee baby lawyer working for Jim Rill, who spearheaded the International Competition Policy Advisory Committee, the U.S. has played an important role in establishing harmonization and convergence in the international arena. It's a point I opened with, and it's a point I'm closing with, because it is incredibly important. Through the OECD and the International Competition Network, the U.S. has facilitated the adoption of sound antitrust enforcement premised on rigorous economic analysis and procedural due process around the world. And as the U.S. walks away from the consumer welfare standard, it gives other countries the right to do so as well. If you look back at that ICEPAC report, you see the parade of horribles that we are now welcoming. We'll see more and more countries returning to the good old days of protecting national champions and condoning the adoption of barriers to entry that exclude U.S. companies from their internal markets. We also see some red flags warning that the U.S. may have overstepped constructive cooperation with its overseas partners and instead moved into destructive forum shopping. It would be constructive for the agencies to issue a policy statement on interactions with international partners that affirms areas of commonality, like the consumer welfare standard, procedural best practices, and substantive analysis, and reintroduces firm limits on cooperation that could subvert due process or amount to forum shopping. Thanks so much for listening. I appreciate it. And I look forward to the panel discussion. It's going to be great.
Is this working? Yes, victory. Commissioner Wilson has graciously agreed to answer some questions. If you do have a question, one, wait for the microphone because that's how it gets recorded on the live stream. Number two, stand and identify yourself. Number three, ask your question in the form of a question mark, in the form of a question with a question mark at the end. The floor is open.
Forgot about agreeing to answer questions, but I'm always happy to answer questions.
So let me ask, take the prerogative and ask the first, which is, a lot of commentators have noted that the FTC doesn't have a great batting average in court, and that speculate that if it continues down this road, it will damage the reputation of the FTC as an entity and impair its ability to do its job in future administrations beyond. What do you think of that argument? Are you concerned about that?
Absolutely. I mean, there was a point at which I was telling people, maybe including Noah, I wasn't sure we would have a Federal Trade Commission in 5 years because there were so many detractors from Senator Lee and the One Agency Act and the Federalist Society talking about how it's unconstitutional and so on. And so when you continue acting in ways that highlight the vulnerabilities and weaknesses of the institution, it does not do the institution any favors. So I think the litigators at the Federal Trade Commission are excellent, but the quality of the matters that they are litigating is relevant to the outcome. This is not about the staff. This is about the cases that the commission is voting out and choosing to waste precious resources on. Unfortunately, it's a win-win situation for the commission, because if they win in court, great, they get credit for advancing a very aggressive agenda. If they lose in court, they can take those losses to the Hill and say, see, the antitrust laws are weak and infirm, and we need to make them stronger.
Hi, I'm Tirza Duran. You mentioned earlier that the horizontal and vertical merger guidelines might have room for being updated. I was curious, do you have any initial thoughts on how they could be updated, or was that just kind of they might be able to be updated?
So there are great papers out there that have been written by people like Carl Shapiro and others who say, here are good, wise changes that we could make to the 2010 horizontal guidelines. With respect to the vertical merger guidelines, there may be some important points in recent cases that should be incorporated, but Noah and I worked very hard on those with Chairman Simons, and I think those reflect almost state-of-the-art economics and legal analysis, and so updating those would be very much at the margins.
Gordon Gray, AAF. I was just curious if you could characterize or speak to the MOU between NLRB and the FTC, and just characterize sort of the risks that involves, and I'm just curious.
On its face, it is relatively bland, but it talks about sort of cross-pollination for the two agencies. And I would just note that the FTC's mission is to protect consumers, and the NLRB has a very different mission. And you can only maximize one value at a time. And as soon as you throw labor and other values into the FTC calculus, consumers will suffer. And I was telling Fred this before we got started. We had some property in West Virginia before COVID. And when the FTC closed at the beginning of COVID, my husband and I and our kids and all the animals moved out to West Virginia. And that gave me, I think, a relatively unique insight with respect to, at least FTC policymakers for sure. The people that I go to church with, the people that live around me, are policemen, they're plumbers, they're electricians, they're beekeepers, they're teachers. They do not have a lot of disposable income. And when Tim Wu writes an article, an op-ed in the New York Times 3 months into COVID and says, flour costs too little, at a time when 30% of the American population was unemployed and baking bread at home because they couldn't get to the grocery stores. He's saying flour should be much more expensive. And I can't tell you how appalled I was. The lady who does my nails talks about how her husband has been in a job for 5 years and he has not had a salary increase. But his healthcare expenses have doubled and the price of gas has continued to increase. And he is now driving an hour each way each day to get a paycheck that pays only for his healthcare and his gas expenses. And to be flippant about how low prices are a luxury and they involve theft from the workers and prices should be higher is such an ivory tower concept. People need to get out and meet my neighbors who don't have 2 cents to rub together. They are hunting for deer so they can put meat on the table. They're growing huge gardens in the summer so that they can the fruits and vegetables so that they can eat that during the winter. They don't have money in their wallets to pay for Lina Khan's and Tim Wu's theories.
On that, please join me in thanking Christine. So if we could have the panel come up. It's my privilege to introduce the moderator, Rebecca Klahr. Rebecca is a technology reporter for The Hill and covers antitrust, obviously, privacy, disinformation and whatever else the tech world throws at us this week. She is more notably a graduate of Binghamton University, famously the alma mater of Tony Kornheiser, and soon to be famously the alma mater of Rebecca Clark. Thank you.
Thank you all, and I'll introduce our panel today. Joining us, we have Tim Murris, former chair of the FTC and visiting senior fellow at the American Enterprise Institute, Noah Phillips, former FTC commissioner and partner at Cravath, Swaine & Moore, and Diana Moss, vice president and director of competition policy at the Progressive Policy Institute. Thank you all.
Thank you.
To kick us off, I was wondering if you all have any reactions or remarks to what we just heard from former Commissioner Wilson, if you want to start.
Sure. So first of all, thanks to you, Rebecca, for being here as our moderator. Thanks to Christine for that classic speech. Christine gives it to him. And thanks to the American Action Forum and Doug for having us here today. It's a real honor to be here. It's a real pleasure to be here with Diana and with Tim, who are terrific folks, as you're about to hear. I think my main reaction is that there is a dramatic change going on in antitrust and antitrust enforcement specifically, less so in the law, more in the enforcement. But the way, and there's been a lot of writing about the drama of the change and the fact of the change, but there's been quite a bit less written by the press and by others about like what that means on a practical level. And I think what you heard from Christine was a lot of specific policy changes, many of which are not particularly interesting to read about if you're not an antitrust wonk like I am. But they matter a great deal. They matter to the people in the economy who are buying products and services. They matter a great deal to the companies who are trying to get things to happen and figure out what's legal and illegal in order to provide those goods and services to people. And the particulars matter a great deal. And oftentimes, I worry, we don't get a lot from the rhetoric. We often don't get a lot from the press coverage about what's actually going on. Like, agency loses case. Why did they lose the case? Agency wins case. Why did they win the case? You know, Christine noted the Illumina case and talked about how, to her mind, it was a very traditional theory of vertical foreclosure. There have been some wins. There have been some losses at the agency, but I think what's critical to look at is like, why are they winning when they're winning? Why are they losing when they're losing? Because it is in sort of these small places, you know, in the particulars of policy and its application, where I think we can judge, you know, how are things going. Not all the illegal mergers that are happening since power changed hands with the Biden administration are illegal in new ways, right? If you look at what judges are crediting, they're crediting evidence of lessened competition, right? The people were planning to compete. They were reacting to each other in the market. And after this, they won't be. That's not new. And to be clear, the agencies should continue to police illegal deals. What I think matters the most, Christine said a lot of really important things, but her focus on detail is something that I think is incumbent upon those in the policy world, those in the press, really to pay attention to, because at the end of the day, that's what matters.
Well, first, great to be here. Hi, everyone, and Christine, just amazingly perceptive and honed-in remarks. I have a lot of reactions, but in the interest of limited time, I will say this. So the neo-Brandeisians are not having an easy time of it, right? This is an uphill haul for them. They are pushing boulders up hills on many fronts, on the enforcement front, on the policy front. It is not clear that the Biden agencies are executing on the executive order on competition that came out in July of 2021. When they are executing, we have some reservations about how that's happening. The junk fee rule that came out of the FTC, I think, has some serious flaws in it. It fundamentally confuses consumer protection with competition. You know, are we really going to tell Frontier and Spirit that their bag fees are junk fees? That's an a la carte unbundled model that some consumers really value. and that's the way they want to fly. They're not flying like all of us on our United Global Services status. That's a whole, I'm not global services, by the way, but it's, almost. No, it's, so I'm not sure we're seeing a particularly good alignment between what the Biden folks in the White House really envisioned in terms of a focus on competition as a political and economic policy priority and what's coming out of the agencies. And I think the FTC is more under the microscope than is the DOJ. But I do want to reiterate, this is not easy going for them. And we'll talk more about this in a minute, but the merger guidelines are a really good case in point. I am a center-left pro-enforcement person. I have ran the American Antitrust Institute for a long time. I'm now at Progressive Policy Institute. I am not a neo-Brandeisian by a long shot. I am what you might call a post-Chicago economist that advocates for stronger competition, but based on evidence and good analysis, legal and economic and business analysis, but focusing on areas where we really see serious market power problems. The merger guidelines, I think, in revised version, are not what they were in draft version. There is still a consumer welfare standard embedded in there, but they were forced to backpedal and retrench because of all the pushback they got from the center and the center left. So it's in there. We no longer have bright line tests for, mergers should not do this, mergers should not do that. That's all been changed. But here's my concern. We now have new guidelines that are much longer, more detailed than what we had in the 2010 guidelines. Whenever you put out guidelines that attempt to make big change, you run the risk of having them pulled back. And so in 2 years or longer or less, these new guidelines might well be pulled back, much like previous guidelines have. And I think in the effort by the neo-Brandeisians to make some progress in shaping ideology in the antitrust space, when we look back, we may well see several years of I don't want to say wasted energy, but confusion, muddling, lack of transparency. And remember, antitrust is all about the courts. So if you confuse federal court judges, especially generalist judges, about antitrust, which is a wonky area of law anyway, you are not making forward progress. And I do foresee, a next few years where there's going to be a lot of unwinding and reframing and backpedaling. And what does this all mean for sort of the bigger antitrust enterprise, which I think we can all agree is really to promote competition in markets for the benefit of consumers, workers, smaller businesses, innovation, high quality products. All these things that are sort of embedded in the consumer welfare standards. So that's I'm out on the front of the ship looking into the horizon for what's coming next. And I don't see a particularly happy story evolving.
Well, let me also thank Doug and Fred and AF. It's a pleasure to be here, although you got me here from Florida, so I don't know about what pleasure that is. Let me. It's a great pleasure. Yeah, great pleasure. It is. Let me make Christine groan and start with John Wooden. I went to UCLA at the end of his tenure. For those of you who don't know who John Wooden was, Coach K, who just retired from Duke, when John Wooden died at age 99, he said you could have a serious argument about who the second greatest college basketball coach was, but there's no argument about who the first was. He won 10 national championships in 12 years. I was at UCLA during that tenure. And he's more famous in many ways for the life lessons that he gave to his players. One of his favorite sayings was, "Never mistake activity for achievement." And I think we're seeing a lot of activity and little achievement. There's nothing wrong with what they set out to do. It's the third time in over 50 years someone has walked into the FTC. It happened in the beginning of the Nixon administration, beginning of the Reagan administration, beginning of the Biden administration. People walk into the FTC and say, this place needs fundamental change. There's some great differences, however. In 1969 and 1981, there was bipartisan agreement that fundamental change was needed. In 2021, the FTC, Global Competition Review, rated competition agencies. In the 21st century, the Federal Trade Commission was the only, and I mean the only, of all the world's competition agencies that were rated, the only consistently every year 5-star rated agency. When the president talked in one of the many insults that began the administration toward the FTC, 2 weeks after Lina Khan became chair, I guess it was 3 weeks after, and he said to everyone at the FTC and who had been involved that you were part of a failed 40-year experiment. Nothing lasts for 40 years in Washington at all these days, but certainly nothing lasts for 40 years unless there's a bipartisan consensus. But nevertheless, he walked in, appointed Chair Khan in the first of many breaches of norms. She was confirmed with considerable Republican support, immediately lost that support because unlike everyone else who was made chair, myself for example, when I was nominated, when Bob Potofsky was nominated, when other people were nominated, unless they were already there, to be a commissioner, and the president intended to make them the head of the agency, the president said, if you confirm this person, I will designate them. That's the president's power. I will designate that person as chair. That's not what happened. The minute Khan was confirmed, the president said, oh, by the way, I will make her chair. That was the first norm that was obliterated. Next, Khan essentially fired the people that had been put into place by the person Biden made acting chair, another Democrat, Rebecca Slaughter. And in another norm breaking, she chose essentially Commissioner Chopra's staff to be her staff. Now, people who are attorney advisors, there's a lot of history of attorney advisors in the FTC, and there are a lot of very good people. But the talents to be attorney advisors and the talents to run the agency, to be bureau directors, there's very little overlap historically between that group of people. And people, if they do later become bureau directors or managers, they have other jobs in between. They don't immediately jump, but that's what happened. The next thing that happened were the insults. I mentioned the Biden insult. A second insult was a meeting at which Noah and Christine participated and dissented. It was a meeting where on July 1st, again, 2 weeks after she came in, where there were many major changes. And the career staff, who always would have participated in those sorts of meetings, did not participate. Then, around the same time, the new chief of staff told everyone in the career staff, you can't go out and talk in public anymore. And she told them to lie about it. She said, you can't, the reason, you have to give a phony reason for it. This went on and on and on. And of course, the career staff reacted dramatically. Many of them voted with their feet and left. And many of these people who left are people who would have never left before. A lot of what they were reacting to were the views of Commissioner Chopra. Commissioner Chopra and Donald Trump shared something deeply in common. They believed in the deep state. Commissioner Chopra, and I'm not telling anything here that's not open and notorious. Commissioner Chopra had a deep, now of course he runs the CFPB, he had a deep-seated animosity toward the career staff in Washington in the Federal Trade Commission. He even asked for an inspector general's investigation of one particular division. He believed in there's something called the revolving door project. When he came in, he was listed as the principal author of something about the revolving door for the Roosevelt Institute. It's a belief, contrary to considerable evidence, that career staff at places like the FTC are nothing but tools for corporate interests. And it was a problem another failing and a problem of the people who run the agency. Now, they maybe have learned by some of their recent appointments, but let me contrast, and I'll finish on this, with one of the differences what we did in the Reagan administration when we took over and what they did. Now, we had our troika of people to work on policy. I was very proud of the fact that I had the late Fred McChesney, became a very famous law professor who worked on cases. Howard Beals, who later became, these are both PhD economists, and Fred was a lawyer, very close friend of mine, both of them. Howard Beals worked on rules, later became director of the Bureau of Consumer Protection. But we wanted to bring fraud cases, among other things. If you put a shotgun to the three of our heads, we couldn't have told you how to bring a fraud case in a million years. So we went out and found people in the agency and outside the agency to do it. We didn't give a damn whether they were Reaganites or not. What we cared about was, could they litigate, and were they committed to going after fraudsters? Okay, the neo-Brandisians, when they started, and at least for a couple of years, like I say, they've shown some signs of making a change about this, they wouldn't go to the Washington law firms, which were comprised mostly of Democrats, and lots of 40-year-olds who were expert in litigating, expert in doing rules, the kind of people they needed to implement change. They wouldn't hire them because they thought they were tainted. There are just many. Howard Beals and I are working on a piece about the failure of I guess I should be grateful for this, of Chair Khan as a change agent, and that's one of the what I've been talking about here are one of the many flaws. But going into the agency with a series of insults, assaulting the career staff, and not laying the predicates for change are some of the many failings.
Thank you all. So I know in talking about what the FTC's action has been lately, I think one of the major actions they've taken along with the DOJ are the updated merger guidelines. So to start, I know we also want to get into concerns about the cost, which I know Diana has done work on. But to start talking about that, what are some of the most immediate impacts that you think the merger guideline updates will have, both in terms of how it could help or hinder antitrust enforcement?
So, what I do all day is counsel clients on antitrust conduct, but also on mergers. And so when the antitrust agencies put out guidelines, that's a very important thing that we need to take into account when we counsel clients. Broadly speaking, the message of the new guidelines, whether it's the lower thresholds for what trips you into presumptive illegality for purposes of the agency's review, or some of the other ideas of how you get to illegality, the broad message is a lot more transactions are illegal. That's the broad message that they're sending. One of the issues with that, there are more than one issue, but one of the issues is that it's not clear to me that the agencies are actually challenging all the things they say are illegal. So there's a disconnect. There was a lot of flack thrown at the 2010 guidelines for raising the thresholds of concentration. What that was based on was a study of when have we actually intervened. So the agencies were saying to the market, even though before we had said this number of deals were illegal, this is what we've actually seen when we've done the math and we've done the homework and we've brought the challenges. And based on this, here's where we're going to set the test. So we've walked back, not because we have new economic evidence that shows that at these thresholds we're likely to see a substantial lessening of competition, not because we have new case law from the courts, and in fact, for all of the talk about these guidelines being about precedent, they go well beyond even the 1960s precedent, a case called Philadelphia National Bank, which sets sort of a test of a level of concentration at which a court will presume a horizontal merger to be illegal. What they do is they just sort of raise the number of illegality, and it's also not based on agency experience. So you have a gap between the guidelines and a gap and what they're doing, and that makes counseling clients the exercise that I engage in, that so many other lawyers engage in every day, more difficult. Because what you have to say is, look, in certain cases, they will say this is illegal, and they might view it that way, but I really don't know that they're going to do anything about it. And that's a problem for purposes of business planning. You know, people want to follow the law, and lawyers want to counsel their clients in light of what the law is. And the further the guidelines go from practice, from law, I think the more uncertainty it creates. And this comes back to a point that Christine was making. I do think, and I think to me one of the broad themes that we're seeing, one of the big changes in the new administration's approach to antitrust, I do think there is a desire, and I talked about this a lot when I was commissioner, I called it the merger tax. There's a desire to add costs kind of across the board. So one of the ways that you do that is like the HSR, the proposed HSR reforms, where regardless of whether the deal has any likelihood of being illegal, regardless whether it's a merger, right? Some of this is like executives converting their warrants into stock in companies that happen to trip the guidelines. They're going to tax everything. Another way to do that, there are two other really good ways to do that, and I think we're seeing a lot of them. Another way to do that is uncertainty, right? A lack of clarity in what the rules are. And yeah, we have the guidelines and we can all read them, but there's a lot more room in the joints and a lot more suggestion that things are illegal. And I suspect we're going to see a lot of deals that are illegal happening, not because they actually lessen competition, but just because the guidelines now say that so many more things are illegal. The other thing I'd add, the other strategy, I'm going to get the name wrong of the article probably, but Tim Wu years ago wrote an article called Agency Threats or something like that. And the basic idea was that like you can move the needle through enforcement, you can move the needle through rulemaking, maybe you can move the needle through policy statements, and we see a lot of policy statements. But agencies can move the needle in terms of the conduct of actors just by saying things loudly. And I feel like what we have seen is a lot of fanfare, right? There's a lot of, and there's a lot of statements by the agencies, but also like there's a lot of coverage and a lot of hype. And you know, that has some value in drawing attention to what's going on, but I worry it's more of a deliberate strategy to effectuate through a mechanism that isn't subject to due process, it isn't subject to courts, it doesn't go through notice and comment, or all of these checks and balances that we have to sort of mediate how law enforcement and how regulation are effectuated in our society, but it's very easy to do. And so I think that, you know, the guidelines, when the draft was announced, what you saw a lot of people talk about was like, this sends a message, right? This makes a statement. And I really do think I mean, I'm not a particular fan of this way of doing antitrust enforcement, and I don't think it's really enforcement, but I do think one of the things the merger guidelines really do succeed at is in making that loud statement.
Here's another perspective that might be helpful in terms of how you think about these new merger guidelines. And I'm writing an article on this right now for concurrences. It really breaks weirdly neatly into three different areas of focus. One is, what do the guidelines actually give us that that the previous version did not give us? And I'm talking about theories of harm, right? We're down into the trenches and actually thinking about theories of harm, right? Highly concentrated mergers, elimination of head-to-head competition, and stronger incentives to collude. Those are what we call theories of harm. What do the guidelines give us in terms of guidance, actual specific guidance, theories of harm, that we didn't have in the 2010 guidelines? The second category is, how did things change between the draft version and the final version? And this harks back to what I said earlier about things got pulled more to the center left because of all the pushback. And then the third category, and I'll backfill here in just a sec, the third category is, what do we need to be watching out for moving forward? Where could these guidelines pop up and present situations to companies, to enforcers themselves, to the courts, to the consumer advocates, that really create uncertainty and fuzziness and a lack of transparency moving forward? So on the first one, we now have 11 guidelines, down from an original 13. And they unpack into two categories. One are the actual, what they call the frameworks guidelines, which are theories of harm that I just described, gave you examples of. And then there's this new type of guideline called an applications guideline. And those are scenarios or settings where the agencies feel that the frameworks guidelines have special application. So things like multi-sided markets, things like mergers that create powerful buyers of inputs, for example, partial acquisitions. The list goes on. But the bottom line, and check me on this, most of those are in the 2010 guidelines. This is not carving new territory. We have highly concentrated mergers, elimination of head-to-head competition. There's some new stuff. We now have integrated vertical guidelines. There's a new guideline about entrenchment or extension of a dominant position. On these application guidelines, we now have the more dynamic scenarios of trends towards consolidation and serial acquisitions. But bottom line, I haven't done the number, but 75 to 80% of those scenarios and those actual theories of harm are in the 2010 guidelines. We're not hoeing new ground here necessarily in any significant way. Okay, so that's number one. Number two, pulling the guidelines to this center. If you read section 1 and section 2 of the guidelines, think about this. Judges, the guidelines are non-binding on the courts, which Christine said, but they pay attention to them. And the public pays attention, and consumer advocates pay attention. And by the way, that language is gone now. It's not in there anymore. There's a very important sentence in the 2010 guidelines that said, these guidelines are designed to help the public, the courts, practitioners, businesses, consumers to understand how the agencies will go about evaluating the legality of mergers. That language is gone, which leaves us with the feeling that there's like a lot of hubris here. It's all about the agencies and what the agency agenda is for this particular set of enforcers. So without going into great detail, there are a lot of areas where the guidelines are pulled to the center. We no longer have bright line tests. Mergers should not do this. Mergers should not do that. That language has been revised significantly. The guidelines now explain what market power is, which is sort of basic to merger control. It didn't do that in the first version. So there have been a bunch of changes, and we suggested a lot of these changes that pull the guidelines in from the hard left more towards the center to create a transparent document, to create predictability for the public and for the business community, to understand what are the guidelines trying to do, what is market power, how is it exercised, what are the effects on consumers in terms of prices and quality and innovation. None of that was in the draft. And as Christine aptly pointed out, all the economics were shunted off to the very end in an appendix. And there's been some restructuring which changes that a bit, but it's still a very separate section where the economics is. And then finally, what to look for moving forward. 4 major areas I think are going to prove problematic. First of all, the guidelines are peppered, and I cannot understate the word peppered, with the disclaimer that they are non-exhaustive. So non-exhaustive, these are non-exhaustive. The agencies are limited in no way to search out and to propose and to explore different theories of harm, different applications, different settings.
So much for dropping the last guide.
So lots of non-exhaustiveness talk. Second, these very dynamic setting of applications guidelines, trends towards consolidation, how to evaluate a series of transactions, for example, killer acquisitions. We do not have any better guidance in the final version that we had in the draft version, and that's virtually nothing. So that will, to your clients, Noah, that is going to be when those transactions pop up, and that's a possibility that the agencies may propose that as an application of a guideline that could be potentially problematic. And then third, we have this, what I call the vertical mega guideline, which is pages and pages of exposition on vertical mergers and what to look for and conditions. And I mean, it's all there and correct and right. It's not presented in a way that a generalist judge would find very friendly or transparent or easy to deal with. So I think these last few factors moving forward are going to pose challenges for the courts, especially and for practitioners and businesses as to how these guidelines will be applied. Are there any limits? You know, can this be bounded within the document or slightly outside the document, or is the sky the limit in terms of what the agencies will be looking for? And you know, I'm a pro-enforcement advocate. I think we should get strong merger law and strong case law that can be cited as precedent. And I'm not sure that these guidelines are going to achieve that very important goal.
Well, let me approach this from the standpoint of courts, and I understand, Diana, a lot of people, John Baker and others are saying, look how much different this is than the draft. Well, a court's not going to give a damn about the draft. The comparison the court's going to make is between 2010 and now, the final version. And the final version, let's just go back to Noah's point about the numbers. The final version makes a massive, and I mean massive, change in the numbers. And are they going to mean it? They go back to Bill Baxter's, and I had the honor of spending a lot of time with Bill. I was director of the Bureau of Competition for a good part of Bill's tenure. And he made 6-5 the marginal case, 1,800 if you take, you can do the math. 5-4 is 2,000, and 4-3, which are the 2010 guidelines, is 2,500. Just it's the magic of squaring. If you know, for those of you who are arithmetically challenged and want to figure that out, but you can work it out. But think about what a difference that makes. Okay, but let me explain first a little bit about how those numbers were derived in much more detail than Noah did. The FTC took a data series and it released this over first in the Bush 43 under me, then under Debbie Majoris, then in Obama under John Leibowitz. It released under every second request that occurred going back to the Clinton administration through early Obama. Every second request, the universe of a long data series, and it looked at the memos from the economists and the lawyers, and it divided, it looked at things like concentration, the number of significant competitors, what the staff said about entry, what it said about customer complaints, key variables. And what they found was, it was reassuring. It found that efficiencies mattered. It found that customer complaints mattered. It found that entry mattered. And they found that 4-3, essentially, it was slightly different between whether the theory was coordinated or the theory was unilateral, but 4-3 was essentially the marginal case. And by marginal, I mean literally that they were about as likely to challenge as not likely to challenge. Now, it doesn't mean that in 5-4s, there were a lot of 5-4 challenges. It's just, and there were 3-2 cases where they didn't challenge. Now, there were a lot more 5-4 challenges than 3-2 non-challenges. But there were important 3-2 cases. Boeing, McDonnell Douglas was probably the most important one in the Clinton administration. The Airbus, I guess, is Airbus and Boeing were the two remaining ones. And they decided that McDonnell Douglas was, you know, after talking to the airlines who were buying these things, that McDonnell Douglas was just not going to be a significant competitor in the future, and they were better off. The airlines thought they were going to be better off with the merger, and they were the customers. So. And but there weren't many challenges at 6-5 over this long period of time. So now we're saying we're going to move back to challenging at 6-5, and they're not basing this on evidence. Now there are some empirical studies out there. There's what looks like a good study in the retail industry, which is an area where an NBER study. It's an area where the government actually challenged. There were a lot more 5-4s. Energy was one area where there were a relatively higher amount of 6 to 5s that had peculiar reasons that I could describe offline if anybody's interested in. Bilal Sayed and I wrote this long tome on the FTC, and the oil industry, published in I think it's in a Southern California Law Review. But the point is, even anything that's published now, including that study, doesn't know and have antitrust markets. So it's very hard to do a study. The government could do a study, but the point is, when a court looks at those guidelines and compares them to the 2010 guidelines and the history of the 2010 guidelines, and if the government is really trying to make this gigantic move, they're going to be in trouble, I think. And in that sense, these guidelines are a damn big deal. And we'll see if they really mean it. Baxter meant it, and in the Reagan administration, we actually enforced. We bought a 6 to 5 music case, won it in court. I was a bureau director. I thought that those were the guidelines. It turned out later we actually let a merger music case go later on when I was chairman with lower numbers, based on all the experience and everything. But this is a really big deal, regardless of any positive developments that occurred in the changes from the draft guidelines to the final guidelines. That big move in the numbers didn't change.
Yeah, and I think another big discussion around the merger guidelines updates is the cost associated with it. And if you want to start, Diana, about
sure.
the cost associated with the update and what that could mean towards the agency's effectiveness.
Yeah, so
You're talking about 7A, right? The HSR.
what are we
Is that
are we
what you're
talking
talking
about actual enforcement stats, or are we talking about the HSR requirements? Changes
Or
in
both.
HSR?
Both, yeah, both would be good.
Okay. Well, I'm happy to respond to that first. Changes to guidance, what will be the material impact of the guidelines? How does that compare to what the agencies are actually doing right now? I collect and maintain, because I'm a wonky economist, all the merger enforcement statistics going back to 1993. So that's 5 administrations worth of data. And we generally see upticks in enforcement vigor in Democratic administrations, downticks in GOP administrations. The Trump administration is a very distinct exception to this, where there was pretty vigorous enforcement at the agencies during that time. We also had COVID, so there was all this pent-up demand for getting mergers through in 21. That was the big spike the first year of the Biden agencies. But here's the bottom line. Both agencies have extolled their invigorated merger enforcement programs as exceeding all others and record highs. But man, the statistics just don't bear that out. They don't bear that out, and statistics don't lie. So for example, the rate of second requests is down under the Biden agencies as compared to previous administrations. The rate of challenges is down across for the Biden folks as opposed to previous administrations. What is not down is the rate of what we call merger denials. So that's an injunction, go to federal court, litigate your deal. That's a forced abandonment of the merger, or it's a forced restructuring of the merger. Those are mergers that are sort of denied. The other bucket is mergers that are settled, subject to consent orders. This is where we see the major imprint or footprint of the Biden folks, and that is an enormous pop in mergers denied, either through injunctions, through abandonments, or restructurings. And it is the FTC driving that number, without a doubt. It is the FTC driving that number. But here's what worries us in sort of the center-left community. Levels of second requests down, levels of merger challenges down. And I'm talking about rates, right, as compared to previous administrations. So what is with that? This is early stage enforcement, middle stage enforcement, late stage enforcement. And I think the answer that we need to care about is that agencies have limited budgets. It's expensive to litigate cases, right? It's expensive to go to trial and hire expert witnesses on both sides and hash your way through a trial that could go on for weeks and then getting outcomes and appeals. That's expensive. And the Biden agencies have chosen to go that route as a major vehicle for promoting more vigorous enforcement. What does that mean? It means that by doing that, you take resources away from doing second request for more information. You may take resources away from looking harder after a second request into a more full-blown investigation for deals that really deserve some higher scrutiny. So there's been a huge reallocation of agency resources to fighting to block mergers, right? And then you say, okay, well, so what? Other than the resource allocation program, the resource allocation problem, and that, well, so then you ask, well, what's the win rate? Is it working? Is this new strategy working? Well, in 2022, based on the latest HSR report, the win rate is 20%. 5 cases were litigated by the agencies, and only one was won, and that was the book publisher's case at DOJ. And so, I'm throwing out these statistics to sort of put this whole problem into context. Scarce resources at the agencies, these are public taxpayer resources that are being used. Agencies, are funded in different ways. But a program to specifically increase the number of block deals is not a costless program. It is not a costless program. And resources are reallocated out of other areas of enforcement and policy and guidance and that sort of thing to promote this particular outcome. So I just suggest that we think about that as we move forward here. And as we get more cases litigated, we'll see what that means and how those numbers change.
Yeah. Do you have anything to say on the costs that you want to add?
Yeah, I think there's a number of different costs, right? Diana pointed to a critical one, and that is the opportunity cost. Let's just assume that some people are correct that there's lots of illegal deals out there. The agencies cannot challenge them all. So if you're challenging one, you may be missing another. There are also costs to taxpayers because some of the litigation in particular is expensive, and this administration essentially has stopped settling matters. I gave a whole speech about that a few years ago. So there's an opportunity cost to enforcement, and the bigger, more expensive, more flamboyant really a case, the higher that opportunity cost is. Resources that could otherwise have been allocated perhaps to less interesting and less press-worthy matters, but nonetheless important things like hospital mergers that really drive up costs for people who need medical care. So that's opportunity cost. The other cost is, and this is especially so whether through uncertainty or through the reforms to 7A, to the Hart-Scott-Rodino filing rules, which we haven't really talked about that. Christine touched on it. It's worthy of note. The agencies have put out a dramatic reform in all of the paperwork that you need to do when you bring a deal to the agency. And on average, the agency will look at 2 to 3% of deals. But for 100% of deals, we're going to have a multiplication in the cost. By the agency's own account, by 4. So that means for 97 to 98% of deals that the agency shouldn't be spending any time on, people are paying 4 times as much. Again, that's just the agency's statistics. I think there are others who think, and I agree with this, the actual cost is much higher. What that means is that a lot of transactions, like money is going to be allocated to doing those transactions from, let's say, research and development or salaries to lawyers. Like that's the wealth transfer that's going to go on. That's a cost. The other cost is it's going to slow down. This is my sand in the gears line that Christine referred to. It's going to slow down markets from working. Some of these are merger markets, and there's a whole literature you can read about what we call the market for corporate control. People who can better operate an asset, run it better, will have a harder time getting access to that asset. The other thing it will do So it will drive up the costs of markets. And some of these markets, to be clear, these aren't just M&A transactions. These can also be like large securities transactions. If you care about corporate power, if you want executives at companies to be accountable, making it more expensive for people to buy stakes in those companies and advocate for running those companies better is not a good strategy. This is going to make the cost of, this is called shareholder activism, much, much higher. So these costs are not always going to be readily apparent, right? It's going to be harder to see them, but lost in a lot of the conversation are going to be higher costs for consumers who would have benefited from deals that don't happen, higher costs for shareholders who don't benefit from that policing of corporate conduct that shareholders do. And if you look at every SEC from time immemorial, Democrat and Republican, they have always advocated for more shareholder power. This is a cut against shareholder power, so I think that's a real cost as well.
Look, and a comment on both of these issues. It is interesting over time, but following up on what Diana was saying, the agencies have had different approaches to mergers, and in some administrations the FTC is more aggressive. If you look at the statistics, when I was chair, we were more aggressive in 2 of the 3 years that I was chair, and in 1 year it was about the same. Sometimes, I wrote an article about this with help from Bilal Sayed, the mix of mergers between the 2 agencies can differ. The DOJ in 1 year in the Clinton administration spiked, and a lot of that was because like good duopolists, the agencies collude and divide things up. The mix to DOJ had industries that were merging, and they took a lot of deals. But the question of deals and the unwillingness of the Biden administration to take deals is quite odd. There are people that assert, they're lawyers, and I don't know the facts about this, there are lawyers that assert that, in fact, there is this sub rosa fix it first program which is problematic in the sense that it's, from the government standpoint, it would be better to take a decree or a consent, because that way you've got something you can enforce if something goes wrong. But what happened in the Amgen Horizon case was particularly problematic because and there's no reason to disbelieve what they were saying, the lawyers who worked on the deal at the end said they could have had this at the beginning of the process. And instead, they put everybody through a very expensive litigation process. They went all the way up almost to the courthouse steps and settled. And for what point? Well, the point appeared to be we don't like settlements, but if we show that we were willing to litigate, we'll take a settlement under those circumstances. That's quite expensive. On the point Christine and Noah were making, the real extra costs that they are trying to impose, if they get away with it, on the Hart-Scott form, in their defense, the government does look at least superficially, at a higher percentage than 2 or 3%. They asked for clearance on like 13%. But the real percent that they look at is the number with a second request, is the 2 or 3% that Christine and Noah are talking about. And now they want to impose massive costs on everyone. I was in the part of OMB that does the Paperwork Reduction Act at the beginning, before most of you were born. This was 1981. And not you. And I was pointing to our leader here, Doug. And the Paperwork Reduction Act is a statute that says that worries about overly broad paperwork requests. And if there ever was an overly broad paperwork request, it's one that applies where the overwhelming majority of the paperwork requested is not going to be used by the agency. So it'll be quite interesting to see if the Office of Management and Budget, which enforces this thing, blinks, or instead if it requires some significant changes. That'll be for you reporters out there something interesting, some inside Washington baseball, but an interesting thing to watch.
Can I just make one more comment? We're talking about opportunity costs. I think one cost we really haven't covered, and again, this is from sort of the center-left perspective, is if the agencies choose poor cases to litigate and then they lose, then that goes into the case law. That's right into the case law. And as somebody who has worked very hard to promote the evolution of good case law through the choice of strong cases and the application of an analysis of good economic and business evidence and legal doctrine, this is the life I lead. We try to avoid poor case law at all costs because it weakens merger enforcement in the end. If you have a bunch of really bad cases that the government lost, those are going to get cited in future cases. And that makes it harder in the long run to effectuate more vigorous, smart enforcement. So there's actually another cost associated with this of bringing weak cases, losing in federal court, and then having, it's not like it goes away into the ether, it goes right into the case law. The meta within case, for example, I mean, Christine referenced this, but I just want to drive home the point that the allegation was that Meta was the potential competitor. It wasn't within, it was Meta, which has the VR, the VR hardware, the headsets, but also a distribution platform for apps. Within was coming in with the apps themselves in the VR fitness apps. So this merger would have created this complete ecosystem of VR fitness apps, hardware, distribution platform, and the apps themselves. But the FTC's complaint alleged that it was Meta that was the potential competitor. I mean, for those of you who know antitrust, it's usually the smaller company that is alleged to be the potential competitor. And so, but it was kind of a novel theory of harm. Okay, well, yes, some risks need to be taken to advance stronger enforcement, but in this case, this novel theory of harm did not work, and the court wasn't having it. And so now we have a decision in that case that goes right into the case law. So we have to think about that angle, I think, as well, or at least I do, doing the work that I do.
Yeah, I think we have a couple minutes for some audience questions if anyone has anything that they want to ask the panel.
Same rules apply.
Hi, Joseph Brown. So the consumer welfare standard has a lot going for it. It's been around for half a century, something like that. It's, we reason, like a pretty good economic theory on which to base antitrust cases. But I think, as Jonathan Canner notes, it's not in the law. Is that generally correct? And how do you square that circle?
I don't really think that's right. I mean, if you look at Bill Kovacic's got an article, for example, on I think it's the Brunswick case that talks about how antitrust is about protecting consumers, not competitors. That, in many ways, the origin, one of the fundamental origins of the consumer welfare standard. And Bill also points out in that line of cases that the judges are relying on Harvard, not Chicago. Bill has this double helix idea. The whole neo-Brandisian attack on Bork has nothing to do with antitrust. It's because of Bork's notoriety. Bork's book was out of print for a long time. They've made Bork's publisher very happy. They put out another edition. Bork's selling more books. Look, I knew Bork. I spent a lot of time around him. I've read his articles in 1973, his famous articles that he wrote in the mid-'60s on the rule of reason. But he was not he was very important in the downfall of the old order. He was not important in the development of the law during the 40 years. And most of Chicago was less important. If you ask antitrust lawyers, I've done this many times, how many of you in your daily work read Arita and Hovenkamp? Every hand will shoot up. How many of you read Bork? Not many hands shoot up. I'm talking about on a daily working basis.
You know, I think the answer to your question really quickly is it's not a clear cut in the law. So the law is really simple. You know, a merger is illegal if it is likely to substantially lessen competition. It has been agency guidance and the case law that has woven the story of what is a cognizable harm under Section 7. Read the JetBlue Spirit decision that just came out. I mean, that is a victory for the consumer welfare standard. Merger illegal, injunction granted, cognizable harm, higher prices resulting from elimination of head-to-head competition, loss of consumer choice in eliminating Spirit as a low-cost carrier. Wow, that is new. That is relatively new stuff. That is part of the consumer welfare standard. And you know, to the question, early on, the neo-Brandeisians, who are not, by the way, economists and lawyers and that sort of thing, really interpreted the standard as being only short-term price effects, and that is patently false. The consumer welfare standard is dynamic. It can look at short-term, long-term effects, but the trick is to have high standards for showing anti-competitive effects, but also very high standards, rigorous standards for showing efficiencies defenses to those anti-competitive effects.
The one thing I would add is this. What do the statutes say, right? The statutes say, well, in the case of the Sherman Act, which is really antecedent to what we're talking about, it's restraints of trade. And just to be clear, all of antitrust law then follows from the Supreme Court interpretation of that, which is it has to be an unreasonable restraint of trade. Otherwise, every single contract violates the antitrust laws, which is obviously not true and obviously was not Congress's intent. But stepping forward, both to the FTC Act and the Clayton Act, the key word is competition. And it's true, it doesn't say consumer welfare, but it raises this question of like, what does competition mean? The way that the agencies are interpreting it, they interpret it to be like distributed rivalry, just lots of more players. And so you have the trend toward consolidation in the guidelines so that any merger is illegal. But that's not clearly a lessening of competition, right? That's what the statute commands. And consumer welfare is sort of came out of this long time effort to really understand what did competition mean. Is it less competitive when like firms grow because they're offering lower prices and better products to consumers? Of course that's not less competitive, but that is the logic that follows from viewing competition, which is what the statute commands, solely as a lessening of viewing a lessening of competition solely as a lessening of rivalry. Now, at a certain point, right, you get to 3-2 and certainly 2-1. Yeah, it's really to see the lineup between the two. But 6-5, like if you're running an auction and you've got 5 bidders, or you have 6 bidders and then you go to 5, are you still not having a competitive auction? That's not remotely clear as a matter of logic or economic experience.
Last question.
Just taking a step back, we talked a lot about how like the resource allocation is affecting antitrust enforcement, and the loss of staff is affecting antitrust enforcement. Is the focus on some of these big cases and some of the more splashy moves at the FTC affecting its other enforcement priorities, like consumer protection in terms of privacy, traditional fraud protections, or are those kind of siloed and not necessarily one impacting the other?
I think it's a fair question. I don't know how, first of all, the agencies have both gotten substantial increases in funding and increases in staff over the last few years. That's thing number one. Thing number two, the DOJ antitrust division just does antitrust, right? And a lot of the other functions that you were talking about lie elsewhere in the Department of Justice. They do also do conduct cases, right? And so there is a sort of merger versus conduct allocation of resources. I think maybe at the margins, and certainly in terms of the attention of the political leadership at the top, right? The amount of time you're devoting to cases depends on kind of what's coming up through the pipeline. I think so there's more of a reallocation within like the groups that are doing these functions. It probably has less of an effect as you move further outside, for example, into consumer protection.